morning to everyone. Yes, because after that traffic, it would make a great very sociological study in terms of the man I was lost in traffic and its impact on our productivity levels in Trinidad and Tobago. I will express gratitude to the Equal Opportunity for extending this kind invitation to me. Also permit me to extend congratulations to all of you who belong to the Equal Opportunities Commission, led by someone I know very, very well. We go back many, many years, engaged in many, many social activities. I was reminded, Madam Chair, of our days when we were fighting for the inclusion of Clause 4 in the Sexual Offences Bill. Those were exciting days, yes. Yes, which recognize rape in marriage. Thank you. Also permit me to extend congratulations to the Equal Opportunities Commission for developing these guidelines on sexual harassment in the workplace. Reviewing the guidelines illustrated the tireless effort that went into the detailed research and deliberation. Ladies and gentlemen, I also wish to take the opportunity to join with you here, the local community, to commemorate all women and their invaluable contributions and achievements on the occasion of International Women's Day, which will be celebrated on Thursday, 8th of March. I'm also reminded of the upcoming observance of Commonwealth Day, March 14th, which also pays tribute to the women in globally recognizing our struggles, successes, challenges, and perseverance. Sisters and brothers, sexual harassment in the workplace is real. It is real and it is a widespread issue. However, it is also a very broad and ambiguous subject. Many employers and employees do not completely understand what really constitutes sexual harassment or who can be charged with a violation. Yet still, the prevention of sexual harassment is crucial for a workforce that prides itself on rewarding merit, refuses to tolerate discrimination, and fosters gender equality. The work environment is expected to be a place where decent work is practiced, or where employment ethics, respect for women, and equality of all workers should be upheld. Given the caliber of persons that we see here today, I am confident that we are well poised to address any concerns or feedback on this sensitive topic of sexual harassment in the workplace. Ladies and gentlemen, discrimination in the workplace, and more specifically sexual harassment in the workplace, is a global phenomenon which undermines the attainment of decent work. The elimination of discrimination in employment is one of the pillars of the decent work agenda, which has been endorsed at the highest political levels internationally, and actions to promote this agenda have been pursued by the government of Trinidad and Tobago through the ratification of the International Labour Organization, the ILO Convention 111, Discrimination, Employment and Occupation Convention, 1958, and the United Nations Convention on the Elimination of All Forms of Discrimination against Women. Actions have been taken by the government of Trinidad and Tobago to uphold the provisions of these conventions, including enacting of legislation and administrative and policy changes. Ladies and gentlemen, legislative provisions and mechanisms to address sexual harassment in Trinidad and Tobago lie in the Equal Opportunity of 2000, which makes provision for the in the workplace, and the Industrial Court of Trinidad and Tobago, which is responsible for promoting and ensuring good industrial relations in this country. It is the avenue for settlement of unresolved issues. Employers and trade unions who represent the workers of establishments constrained and it is integral to the employment acts of many nations. These include the Industrial Relations Act of 1972 as amended, the Retrenchment and Severance Benefit Act number 32 of 1985, the Maternity Protection Act number 4 of 1998, and the Minimum Wages Amendment Act number 11 of 2000. I pass call a master's reference guideline chair that came to the court trade number 17 of 1995. Sexual harassment was recognized and prohibited as a breach of joy. Here, that it found no assistance in its jurisprudence to a specifically defining the action as sexual harassment. However, the dismissal of was deemed lawful. The employer ensure a work environment and no compensation was granted to this as was sought by the union. That was a matter where of a particular state enterprise accused of sexual harassment, several who came under his supervision, and it ended well because it is a landmark judgment that recognizes sexual harassment at the workplace and what relates to the woman by not reinstating that particular individual. As more women opt to enter the labor market over the past decades, evidenced by an increase in the female labor force participation rates in many regions of the world, discrimination on the basis of sex has become an issue of increasing concern. The elimination of discrimination in the workplace and the promotion of gender equality are therefore central issues in discussions at international, hemispheric, regional, and national levels. It should be noted, however, that there is an absence of specific legislation and policies to address the issue of sexual harassment in the workplace. Ladies and gentlemen, the launch of these guidelines on sexual harassment in the workplace today have been very timely given the increasing number of sexual harassment allegations have taken center stage last year and over the last few months at an alarming rate, not only in Trinidad and Tobago, but worldwide. In fact, as recent as last month, at the Golden Globes 2018, celebrities lined the red carpet in black, not only to shine light on film and television, but also joined forces with the Time's Up movement to highlight sexual harassment in the workplace. The highlight of the evening of the Golden Globe 2018 came when Oprah Winfrey gave a heart-rending speech on the power of hope, finding your voice, and for women speaking the truth. She said, and I quote, "I want tonight to express my gratitude to all women who have endured years of abuse and assault because they, like my mother, had children to feed and bills to pay and dreams to pursue," Winfrey said. "They're the women whose names we will never know," she added. I want all girls watching here now to know that a new day is on the horizon. And when the new day finally dawns, it will be because a lot of magnificent women, many of whom are right here in this room tonight, and some pretty phenomenal men fighting hard to make sure that they become the leaders who take us to the time when nobody ever has to say, "Me too," again, close quotation. My friends, the issue of sexual harassment is both a problem of sex discrimination and gender-based violence. It is acknowledged as a serious issue, a complex challenge, one that is often controversial and contentious and still very distasteful. While some measures have been developed to address the issue of discrimination in the workplace, this offense is reinforced by the absence of policies and procedures and specific laws at the national level to deal with sexual harassment in the workplace in Trinidad and Tobago. However, we at the Ministry of Labor and Small Enterprise Development in our Trust for Legislative Change, we are presently addressing the basic terms and conditions of employment code. And within that code, Madam Chair of the proceedings and Madam Chair of the Equal Opportunities Commission, ladies and gentlemen, I'm pleased to say that sexual harassment provision is being made in that code, because that code is needed in Trinidad and Tobago, as it would seek to provide basic terms and conditions for all workers entering any place of employment. It is my firm belief, ladies and gentlemen, that the awareness raising programs and other advocacy efforts as being done today by the Equal Opportunities Commission will greatly contribute to discouraging the practice of sexual harassment at the workplace. I encourage you to use every mechanism available to solicit the views and feedback from all stakeholders in our society. There must be balance, logic, unbiased focus, and openness in discussions as the next step to lead us to the development of a national policy and legislation. In the meantime, given the absence of legislation to treat with sexual harassment, we encourage initiatives aimed at raising awareness and encouraging the call for the development of sound workplace policy that will discourage all forms of gender-based violence, particularly sexual harassment from workplaces. In closing, Madam Chair, I thank you and encourage you and your team as you garner support to implement these most welcome guidelines. I also wish to remind everyone that words have power. They can build us up, they can strengthen us, they can give us the ability to move forward constructively. In the law, silence usually connotes assent. We need to speak out more. We need to educate more on the harm and the cost of sexual harassment in the workplaces. It is my sincere hope that these guidelines will provide a framework for action going forward. It is also my hope that this recent shining of light on sexual harassment signifies the beginning of the end of a culture which both permits these behaviors to occur and prevent victims from speaking out. A community does not tolerate unacceptable treatment in the workplace, but rather one that is built on decent work principles. Ladies and gentlemen, I thank you.
Thank you, Madam Minister. And we take note, words are powerful. Words are powerful. And we are here today speaking out. We are sharing it. If you notice, we have a panel of women and we are speaking out. So thank you very much, Madam Minister. You know we are working closely with you and your ministry in terms of other pieces of legislation, if need, as it speaks to discrimination and bringing about equality in the workplace. Thank you. Today we are launching our guidelines on sexual harassment in the workplace. And we just didn't want to launch it like that, but we wanted to also share the views of others who are in the area of work, the International Labour Organization dealing with conventions, and also the trade unions who we have to work closely with, our different partners, to share their different perspective on this important topic of sexual harassment in the workplace. And to start off the panel this morning, I have the distinct pleasure to invite Ms. Claudia Cohen-Hart, Director of the ILO Decent Work Team and Office of the Caribbean, who is going to speak on dignity at work, ILO responses to addressing gender-based violence and sexual harassment. Claudia is a Belgium national, and she has been the director of the ILO Work Team Office for the Caribbean since August 2015. She joined the ILO in 1995 and has worked extensively in Africa, Asia, Europe, and North America. Prior to taking up her assignment as the director of the ILO office, based here in Porto, Spain, she took up an 18-month sabbatical from the ILO to act as president and CEO of the Fair Labor Association in Washington, D.C. She has served in many different roles at the ILO. With her depth of experience in the field office, she has acquired a broad understanding of ILO development cooperative activities, as well as expertise in the areas of gender equality at work, child labor, international labor standards, workers' rights, multi-stakeholder initiatives, employment creation, youth employment, job creation in fragile states, social and labor compliance in supply chains in apparel and footwear, electronic and agriculture. She's the holder of a Bachelor of Arts and a Master of Arts in Sociology. We are happy to have Miss Cohen-Hart. Well, you know, I have a problem pronouncing your name. I think, yes. Cohen-Hart, who will share with us the perspective of the ILO.
Senator Jennifer Baptiste, Minister of Labour and Small Enterprise Development, Ms. Lynette Siebern-Sweet, Chairman of the Committee Commission, Dr. Buckles, NATO Representative Ms. Gillian Joy, ECA Representative Gillette Estrada, representatives from ministries, workers and employers organizations, and distinguished guests, a very good morning on my behalf too. I'm very delighted to join you this morning in this panel on International Women's Day. Thank you, Chairwoman, Ms. Lynette Siebern-Sweet, for your vision and initiative. I remember a conversation we had on the topic of sexual harassment about, I think it must have been exactly a year ago, and I could not have foreseen that we would witness today what the Honorable Minister expressed so much more powerfully, but that we would really be witnessing a global Me Too revolution that makes our voice and advocacy on the topic of sexual harassment even more imperative and urgent. So today is not just a moment to ponder and reflect, it's an opportunity to join the global wave that was activated by the force of men and women to address this very important aspect of discrimination in the workplace, the issue of sexual harassment. Let me start by congratulating the EOC for the guidelines. I was very pleased to have a look at them, and I really think it's an excellent document, and I very much hope that today will be the beginning of making a significant use of it by all of us, by all different organizations. Sexual harassment is one of the central forms of violence in the world of work, a topic which is currently under exploration for a new international labor standard, which will actually be deliberated and determined at the upcoming ILO conference in June in Geneva. This was a combined result of the call to the ILO for international leadership on this theme and the broader aspirations in the Sustainable Development Goals, where Goal 8 calls for achievement of full and productive employment and decent work for all women and men, the reduction of inequalities and elimination of all forms of discrimination. Violence in the world of work is a threat to the dignity, security, health, and well-being of everyone. It has an impact, as we all very well know, not only on workers and employers, but also on their families, communities, economies, and society as a whole. Indeed, violence at work and sexual harassment strike at the heart of the ILO's efforts to promote the right of all human beings, and I quote, to pursue both their material well-being and their spiritual development in conditions of freedom and dignity, of economic security and equal opportunity. Up to now, the ILO's international labor standards do not contain conventions or recommendations specifically on sexual harassment. But of course, this does not mean that the ILO has been from this important matter. Although the matter is, as I will explain also more, and the Honorable Minister referred to the convention, to Convention 111, which is the Convention on Discrimination, and it is actually a convention that is ratified by 175 member states, including all Caribbean countries. The convention enumerates grounds on which discrimination is prohibited, and they are race, color, sex, religion, political opinion, national extraction, or social origin. Sexual harassment under this convention is dealt with as a matter that stems from discrimination based on sex. And while the convention, as I said, does not mention the term sexual harassment, in fact, the Committee of Experts application of conventions and recommendations, which is a body of independent legal experts, often professors or judges of various countries, that monitor the application of conventions and recommendations, they have sort of defined what should be understood sexual harassment. Sexual harassment is the expression of sexual violence, which is defined as a sexual attempt to obtain a sexual act, unwanted sexual comments, or advances or otherwise directed against a person's sexuality using coercion by any person regardless of their relationship to the victim in any setting. And sexual harassment is frequently categorized in two ways. The quid pro quo, which is when it occurs when a job benefit like pay rise, promotion, or even continuing employment depends on participating in some form of conduct of sexual nature, or the second form, which is the hostile working environment harassment, and that covers conduct that creates an unwelcome, offensive working environment. It involves a range of behaviors, including sex-based comments, which need not be sexual in nature, disparaging remarks about the sex of the victim, innuendos and displays of sexually suggestive or explicit material, and a single incident is enough to be considered sexual harassment, although it very often involves repeated behaviors. Now, to help you get a better grip of the complexity, and the Honorable Minister was referring to it, it's a very complex, complicated topic also to specifically legislate. I would like to actually just sort of, walk you through a few key questions. One, how prevalent is it? Now, we know very little of the facts. There is a dearth of statistics, and of course, the movement that sort of started last year has started to open up and to make it much more obvious how prevalent it is. But we have very little statistical information on sexual harassment and on gender-based violence specifically, because of problems of definition, methods to measure, and so on. Underreporting is a very serious problem that we shouldn't underestimate, because, well, there is a lack of reporting and monitoring systems, and that can actually easily lead to a normalization of the problem because we don't have it so well written, in fact. We should know that while women are the primary targets, it can also be committed to non-gender conforming men, including men who are perceived to be gay, bisexual, or transsexual. Now, what causes it? There are cultural, structural, and economic reasons. It's often linked to patriarchy. An ILO 2013 study of men from 7 countries in Central America and the Dominican Republic describes how men's sense of ownership or conquering women sets the stage for sexual harassment. While an inclusive and balanced approach to the discussion is important, gender in power relations has a determining role in sexual harassment, and it is important to recognize that. Available evidence suggests that sexual harassment of both men and women most often occurs in male-dominated settings. Low female representation in trade unions is another factor, as a study of 8 countries in Africa indicated that a lack of women in the Union was the reason why issues of equality hardly featured in collective bargaining agreements. Now, another important question is, what is the workplace? When is something work? Where is work? Clearly, it can be situations. But focusing on a narrow workplace will leave out many aspects such as commuting, but also non-typical forms of employment. Current framing for the upcoming ILC discussion on violence at work, which is broader but specifically includes sexual harassment as one important form of violence at work, also the notion of the world of work, which has to capture work that takes place in traditional physical workplaces like offices, but also less typical settings like home or the street. Now, who's most vulnerable? Everyone can experience it, but some groups are more vulnerable. It's more prevalent in low-paid work and supply chains, but we shouldn't forget that it also is pervasive in traditionally high income, and we've seen it in Hollywood, in high income, male-dominated occupations such as engineering, mathematics, technology, science, and maybe we should also say the TV and film industry. Agricultural workers, the largest source of employment for women in developing countries. In a study of 400 women in Kenya, it was found that 90% of all the interviewed women had experienced or observed sexual harassment at their workplace. The ILO has a code of practice on safety and health in agriculture, and it includes a specific sexual harassment module and also a model sexual harassment policy. Another group very vulnerable, domestic workers, of which the ILO estimates there are 67 million. And out of the 67 million, about 80% are women. Also a very important group among that, but not only domestic workers, are migrant workers. According to ILO estimates, we're talking about 155 million men and women, of whom 66 are women, 66 million. Another group very vulnerable are young workers, especially those beginning their careers, and they can be particularly exposed to violence at work, sexual harassment. There are other important factors that enhance the risk of sexual harassment. For instance, tip payment systems in hospitality industries can have an impact on sexual harassment from customers. In Haiti, factory workers with a daily production target are more likely to express sexual harassment concerns. Similarly, temp workers are reported to be more vulnerable to bullying, harassment, including sexual advances. A large survey in Quebec found that both temp and part-time workers were at greater risk of sexual harassment. More directly relevant to the region is, of course, the question of informal economy, which also presents a high risk factor, as it often falls outside the law, but even when not, there is limited room for reporting and for complaint handling. Important in the equation is the fact that reduced capacity for collective bargaining affects the likelihood that workplaces will have prevention and complaint handling procedures in the workplace. And I'm so happy to hear the minister say, that in the basic conditions of work, sexual harassment is going to be a very specific feature, and it may be relevant to look at those specific areas where we know there's more risk or there is more prevalence, that to somehow see that they can be captured in this very important piece of legislation that your government is working on. Now, what is the impact of sexual harassment? I think very important to note is that it reaches well beyond the workplace. It reaches into family members of those who are subjected. And also very importantly and increasingly, we are now not only recognizing this as a very important human right, but it also is a very economically, it affects economically as well in terms of reduced productivity, but also litigation, compensation. In fact, interestingly, a study of the ILO and the International Finance Corporation in Jordan and in Vietnam found a strong negative correlation between average profits and the average level of concern with sexual harassment in the workplace. Now, this is something that we may want to understand more deeply, but I think it certainly is some kind of indication that the more an employer takes an approach of looking after the workers and making sure there is a safe, protected, decent work environment, that actually it can have a very positive correlation with profit making, which of course is very important to the companies as well. Now, briefly, how well are we doing on the response? Well, as I mentioned earlier, internationally, both the ILO Convention 111, but I would also mention Convention 189, which is on domestic workers, are especially relevant for addressing sexual harassment as the new, and of course, the new instrument that is currently under discussion. We are very eagerly looking forward to what will come out of that discussion and whether it will truly result in a standard second round. There's already been a round of discussion last year, so it is very likely that we're going to have a new standard on violence at work. I should say violence at work also includes violence in the health sector, violence in the transport sector, bullying, and so on and so forth. So there are many other forms of violence that need to be addressed, but sexual harassment would be a very important one of them. ITUC, and I'm sure that Joy will refer to that, they've been very active worldwide, including through the global Stop Gender Violence at Work campaign. Well, it's actually raised a lot of awareness in CBAs, collective bargaining agreements, but also global framework agreements. There have been leaflets, there's advocacy and awareness raising on the topic. In 2014, and I'm sure that Giselle will also respond to that, the IOE issued a policy brief on sexual harassment, especially really putting more emphasis on the duty to employers to ensure a safe workplace for all their employees. Of course, that workplace violence is not just, as I mentioned, a human rights issue, but it also is an issue of productivity. Usually, sexual harassment is more commonly addressed in law than other forms of violence, but there remain important challenges in its implementation. One of the important shortcomings is the burden of proof on the victim. And our committee of experts in the ILO has actually been making comments on that regularly through Convention 111, specifically recommending that shifting the burden of proof to the employer be the solution. Sanctions range from mandatory training to termination to payment damages and so on. Most often, the laws cover the workplace per se, but we now see also increasingly workplace codes of practice that go well beyond that. Malaysia is a good example, but we have examples in the region as well. And the newest country that passed a bill on sexual harassment, you may have seen in the newspaper, was Barbados. I know that our chairperson is going to talk a little bit more about that as well. I also wanted to say that besides the law and litigations, enterprises are increasingly recognizing the need for proactive and preventative measures relating to sexual harassment. The employer has a duty to protect the health and safety in the workplace, and this can be laid out in guidelines, as has already been done by numerous employers' organizations who then promote that further with their members. But of course, as long as that is not laid down in legislation, it's a voluntary, more proactive. Now, in Trinidad and Tobago, as the minister also mentioned, Convention 111 is a convention that has been ratified. And in one of the comments that the committee of experts had presented to Trinidad and Tobago, there was mention of, well, there is no specific legislation on sexual harassment, but it also recognized that the government had indicated in a national review on Beijing Plus 20, which was submitted in 2014 to ECLAC, that a steering committee for action against discrimination and sexual harassment in the workplace had been established under the auspices of the Ministry of Labor, with a view to conducting a national study on harassment, as well as sensitization activities and developing a plan of action. I think that today presents a great opportunity to explore how we can pursue this commitment, and as we heard Honourable Minister the work is going on with the legislative part, and so we are very happy to hear that. I really warmly commend you on for that work, but also for visible, clear commitment and hard work to ensure dignity of workers through the legislative agenda and otherwise, and to promote decent work for all. I also commend the Equal Opportunities Commission for having taken this initiative. I'm really so happy to see how we're taking this forward. I think the guidelines are very useful, and this is a great opportunity to start raising awareness, but we need to take it further. We, the ILO, we stand ready to support, whether it is through training, through research, scoping, or policy development, or even in the legislative work. We're partnering with you on the Basic Conditions of Work Act, and so we very much look forward to continue to be associated with this topic, not only in Trinidad and Tobago, in the region. We think it is a very important moment. We want to use this momentum of also the new standard being developed to bring more awareness, to bring more momentum into the region, not only on sexual harassment, but broader violence at work, but sexual harassment. Given the wave in which we find ourselves, we cannot lose the moment to really all come together and take action. And I think today is a great moment. So thank you for inviting me, and we a happy Women's Day in advance, and hopefully we can really take this topic much further. Thank you.
Having heard the ILO, that extensive presentation by the director, we know partner, and that is the EC, the NACHUC. Yes. And presenting on NACHUC today is the General Secretary of the National Union of Government and Federated Workers, Mrs. Gillian Joy Bartlett Allen. Mrs. Bartlett Allen moved through the ranks of NUGFW and has represented the union both nationally and at the regional level on a numerous occasions. As an activist and an avid believer in the empowerment of women, Sister Gillian Bartlett Allen believes education and the acquisition of knowledge plays a fundamental role in progression. She herself attended Cipriani College, obtained a degree in labor studies. She's the holder of a BA in sector management, MSc in government of the West Indies. Sister Bartlett Allen is serving as president of the NUGF Women's Executive Council. She has spearheaded an advocacy campaign, is responsible for the elimination of violence against women and gender-based violence. Avoids the spotlight. She continues to be a woman throughout the region, and she continues to live by the motto, a true empowered the ability to empower other women to bring positive change that would transform the world. We know her role at NUGFW. She will be using guidelines to continue to empower women. It's my pleasure.
Madam Chair. Let me say good morning to the Honorable Justice Primus, the Minister, and I right, Mrs. Lynette Bryan, Chairman of the Equal Opportunities, Beverly Vice Equal Opportunities, Sister Miss Claudia Poinat, ILO, Sister Giselle, and the Director of Employers Association, members of the media, diplomatic and especially guests. And before I get into the presentation, I must say a comment. You know whence I, and you have always been an inspiration, strong, honest, and you are doing a government. Violence is something each one of us would have experienced as long as you're the age that I have passed. Started through the trade union. Before I came to the trade union, I was employed in agriculture, and I must say that I went through harassment, sexual harassment, at an early age as a young girl. I was offered the opportunity that somebody from somewhere, I was this young girl and I should accompany them to someone. I refused because I was paid to do work alone, and that was the job to do. So the passion is out of experience, and the union gave me the opportunity and gave me the voice to become strong, strength in numbers. Workplace violence can be as any negative behavior or action in relation to two or more people in a workplace environment. It is characterized by aggressiveness. It is sometimes repeated and unexpected. It includes and instances where employees or sometimes a officer who are high ranking, because not only employees are abused, sometimes you may hold a managerial position. You are threatened, assaulted, or subject to other acts or behaviors in circumstances related to work. In terms of the global unions and it was done safe at home, safe at work, it noted that harassment and violence are a workplace risk. They try to find out what is wrong and why people are absent from work. And we look at how health and well-being can be improved and prevent place. In practice, we found that harassment was reported as a significant issue by many participants. The seriousness of the issue of sexual harassment is often made to be light, and the victim is usually accused of overreacting. In the EU, 9 million workers suffer physical violence, 3 million are subject to sexual harassment, 13 million to intimidation and bullying. Do we have 9 million overreacting employees? Society has degenerated the gravity of the issue to the extent that what is meted out in the form of sexual harassment is also considered or sometimes considered the norm. Perception has become so blurred and the lines so crossed and distorted that some acts of sexual harassment may be at times tolerated, deemed acceptable by those who are inadequately educated on the severity of the issue. Sexual harassment in the world of work is unwelcome. It is unwarranted. Verbal and sometimes physical abuse. Sometimes we deem sexual harassment to have occurred when someone is victimized because they have rejected unwanted advances. So in other words, sometimes you get the advances and you feel that sexual harassment has not taken place. Yes, it has taken place. In the world of work, sexual harassment offends, it humiliates, it intimidates, it demoralizes, and can lead to unsafe and hostile working environment. Sexual harassment in the world of work has psychological consequences that can lead the victim to suffering physically. Section 6 of the Occupational Health and Safety Act makes provision for recourse for diminished mental health that may come about as a result of sexual harassment. Sexual harassment in the workplace from a trade union standpoint is an occupational health and safety issue for the victims at work and colleagues alike. This is the position that NAT holds on sexual harassment. Some examples of conduct that can constitute sexual harassment are indecent or suggestive comments, questions and jokes, the display of pornography, circulation of pornography by email, Facebook, WhatsApp, and unwelcome and inappropriate touching. In terms of sextortion, the use of a position of power to request sexual services from a subordinated person. Workers who are victims of sexual harassment usually are unable to perform their duties effectively. This negatively impacts productivity, further leading to high absenteeism and loss of productive man hours. This in itself has a macroeconomic dimension to sexual harassment in the world of work, as low productivity has a symbiotic relationship to output of product and services. And in times of economic recession, the goal of employees and governments, private and public sector alike, is to increase output and income. Sexual harassment eventually leads to a loss of wages. As a result, not only is the worker affected, but consequently the entire family and dependents. Workplaces in which there exists flourishing culture of sexual harassment are unattractive and intimidating for workers, especially women, who are most vulnerable. This impedes gender equality and equity and generates a barrier to women entering male-dominated sectors. As trade unions, we are not only charged with much more than negotiated wages and COLA and permanent jobs, but we are mandated to ensure that all workers are privy to safe, healthy working conditions that are conducive to productivity. It is the duty of trade unions to ensure that clear policies and procedures for dealing with sexual harassment and strict preventative measures are outlined in collective agreement. And additionally, workplace violence policies are developed, and not only developed, but escalated throughout the entire organization. In applying a workplace policy on violence and harassment, the tone should be clearly set from the top. Policy should clearly state there will be zero tolerance on acts or threats of violence in our workplace. And our workplace is committed to maintaining a work environment that is free from violence and a threat to workers. All employees have the right to expect a place of employment that is free from behavior that could be considered harassing, abusive, disorderly, or disruptive. Any violent behavior or behavior that creates a climate of violence or hostility should not be tolerated, regardless of origin. Proactive measures will be taken or should be taken to minimize the potential threat of acts of violence. A policy should contain but not be limited to dealing with violent or threatening physical contact, direct or indirect threats, threatening, abusive or harassing phone calls, possession of weapons, destructive or sabotaging action against company or employees, stalking and violation of restraining orders. And we know the story about restraining orders and employees who would have lost their lives even though there was a restraining order out. Trade unions must ensure that shop stewards and labor relations officers are adequately educated on the issue of sexual harassment in the workplace so that the worker can receive the best possible representation. Trade unions must also work with the employer to develop reporting for victims of workplace violence and ensure that they are well trained and to receive and handle cases of violence. However, when the employer is the state or when the employer has high ranking authority in some places, let's face the fact, the accused most likely to seek the best representation from the best trade unions, but these fall on deaf ears and the victim becomes a victim twice. And I heard that Sister Claudia would have said, and in the minister, that in terms of laws, there's no specific laws. And I am glad to hear that the burden will not be placed on the employer, not the victim to prove. What of domestic workers? In fact, they don't even have the sacred right under the IRA as a worker. In fact, for many of them, they stave off unwanted advances daily As for them, their very occupation is more hazardous, as the place of employees put them in the bedrooms of the potential attacker. And this also goes for migrant workers and contract workers and workers who do not have the protection under the laws as it is now, and do not have the coverage of a trade union or even an employer association to go to. Trade unions continue to lobby government for speedy amendments to the Industrial Relations Act. Inadequate legal protection and mandated employer provisions often render domestic workers in a state of living from paycheck to paycheck. This in itself serves to discourage workers from pursuing redress for acts of violence perpetrated against them, as they have to choose between justice and paying the bills. Through advocacy and campaigns, trade unions must ensure that the state or the employer is held accountable for guaranteeing that legislation and that adequately deals with sexual harassment in the workplace is put in place and allows for strong judgment against offenders. The union as well must take up the mandate to educate workers on their rights under the law and various collective agreements. The union must lobby the government to pass legislation and amend laws where necessary to protect workers in the place of employment. The union must also seek to have various government agencies charged with the responsibility having available resources, both human and financial resources available. The Constitution of the National Union of Government and Federated Workers, which is one of the affiliates under the Umbrella Trade Union Center, NATO, makes provisions for a Women's Executive Council and a Youth Council. Over the past 5 years, through the Women's Executive Council of the NUGFW, we have been campaigning for the elimination of violence against women, sexual harassment, and gender-based violence. Advocacy through a national competition in the primary school saw the WEC attempting to break the cycle. And this is the outcome of that advocacy. The aim was to give children a voice and a platform to air different manifestations of violence through their eyes. We have the view that violence only affects adults. Children are affected. Violence on the workplace doesn't stay on the workplace, it goes home. In terms of the worker and the attitude and the scourge and the whole demeanor. You go home and it is manifested in the house. Children grow and they mimic what they see. Even our children are aware that violence is not normal. They are aware that we accept it and we create a hell for them and then we call it heaven. The Women's Executive Council has recognized the importance of intervention at the earliest possible stage of a person's life, as it may very well prevent someone from becoming a future offender or maybe a future victim. Our present project, Her Story, Our Story, a book that highlights the issue of gender-based violence and shows how victims of domestic violence are often susceptible to becoming victims of workplace violence, and this includes sexual harassment. These particular victims are often more prone to being silent sufferers. NATO believes that one of our greatest mistakes that we could make is to believe that issues such as sexual harassment in the workplace, domestic violence, sexual assault, or any similar issue is isolated and disconnected from the other. Trade unionists continue to struggle with the fact that from a jurisdictive point of view, it is difficult to prove a case of sexual harassment. Therefore, many cases are settled through bilateral discussion with the union and the employer, where some sort of compromise occurs. No one goes to jail. Weak, insufficient legislation, no political will, and this is not for the government, this is from people who have authority to make the changes and to break the cycle. Lack of education and gender bias continue to harbor a flourishing culture of sexual harassment. Trade unions have for years been advocates for gender equality and decent work, both of which are key factors in the achievement of Trinidad and Tobago's Sustainable Development Goals. However, sexual harassment harnesses inequality and generates a work environment that endangers decent work. Therefore, there is a dire need for a remedy and a solution that not only brings about redress for victims, but steers Trinidad and Tobago onto a progressive path of equality and gender parity. And no one can discount there's dire need. If we look at the figures for the year, you'll recognize that we are not only in crisis, but I think that we are, if there's something further than crisis, we are there right now. The National Trade Union Center has over the years participated in Life in Leggings, the rally and walk around the Queen Park Savannah. This was led by our General Secretary, Comrade Michael Anisette, to raise awareness against violence against women. In commemoration of International Women's Day, we were there not only as a trade union body, we were the only trade union body there. We continue to host panel discussions throughout Trinidad and Tobago, and the very first Solidarity and Praise concert held by a trade union was held to raise awareness against gender-based violence. That took intention to form among its affiliates a National Women's Committee. Responsibility, among other issues, would be advocacy for policy formulation and implementation of the issues of gender-based violence and of work. Through NATUC, trade union action has been directed towards an ILO convention recommendation on violence and harassment of women and men in the world of work. Comrade Minister of Labour, as NATUC representatives standing here, NATUC therefore beseeches the government that the cry cannot be lack of funding or hard economic times. The opportunity to attend ILO discussions leading up to this convention must be made a priority. Let us press for progress. Many lives are being lost. Many lives are being lost. The future of Trinidad and Tobago is not on solid ground. Violence against women and violence on the whole stands to put our beloved country back in prehistoric days. So let us continue and work together. Let me thank the Equal Opportunity Commission for recognizing that this issue has to be one where there is a multifaceted approach and that all the stakeholders has to be involved. Alone, we cannot do it, but I am sure that if we put all our resources together, that we can, in fact, not only press for progress, but we can progress. Thank you. I didn't even see
Thank you, Sister Bartlett Allen, representing NATUC. We have heard extensively what is taking place at the trade union level, and in particular, NATUC being the umbrella body representing trade union in Trinidad and Tobago. We now move to the employer's representative, the ECA. And representing the ECA here today is Ms. Giselle Estrada. Ms. Giselle Estrada is the director of the ECA. She, in her substantive position, she's currently employed at Republic Bank Limited as the Industrial and Employee Relations Manager. She has over 20 years of human resource experience, 10 of which have been in a leadership role. Ms. Estrada is a human resources professional with a strong knowledge in recruitment, industrial relations, and I can go on and on. She is the holder of a master's in business administration with specialization in human resource management, and also is a professional has a certification in advanced mediation. Ms. Estrada is also alternate member representing the ECA on the Registration, Recognition and Certification Board of Trinidad and Tobago, and a member of the Society of Human Resource Management. We are happy today to have another partner in this program towards eradicating workplace sexual harassment in the workplace, and that is the employer representing the ECA is Ms. Estrada.
Senator, the Honorable Jennifer Baptiste-Crimas, Mrs. Lynette Cibaran Sweet, Chairman, Equal Opportunities Commission, Ms. Claudia Cohen Hartz, the Director of the Ireland Decent Work Team and the Office of the Caribbean, Mrs. Julian Joy Bartlett Allen, other members of the panel, the moderator, Dr. Beverly Beckles, NGOs who are present, ladies and gentlemen, the media, good morning, everyone. We seem to be having some technical challenges because I came prepared this morning to do a PowerPoint presentation, but bearing that in mind, I will try my best to wing it, as we say in Trinidad and Tobago. The employer's role in this whole concept of sexual harassment is a critical one, as we would have heard from the previous speakers. And in that regard, on behalf of the ECA, we want to say that we take our role in terms of guiding employers as it relates to this very serious topic. We take that very critical in terms of being proactive. We are happy today to be a part of the panel. We are happy to know also that as part of the legislative framework, the Honorable Minister is continuing to do the good work that she's doing. And in that regard, on behalf of the ECA, a special thank you to the Minister. What has happened over the years with regard to employers' role as it relates to sexual harassment? As fate will have it, being a member of the Republic Bank team, Republic Bank would have had the first judgment as it relates to sexual harassment. That in itself speaks to the kind of employer that Republic Bank was and is at the time, because that would have been an historical judgment way back in 1995. When one looks at the internal wranglings in that judgment, you would see that action wasn't taken immediately. It took a period of time before the employees came forward. Be that as it may, the employer, having set the tone in terms of a zero tolerance policy, would have said, here's what, we're going straight to the root of the contract, and that resulted in a termination. Because, ladies and gentlemen, sexual harassment is something that comes under the umbrella of misconduct at the workplace. And it means that therefore you cannot attract progressive discipline when it comes to misconduct. It's one of the two things. Either you find yourself in a very unenviable position in the likes of either a warning letter, a suspension, or a termination. And of course, at the time, the good minister did also refer to that judgment. There was no payment for years of service. So while we have the industrial court recognizing equity in service at that particular point in time, that employee did not benefit in terms of any equity of service, because the whole question of the qualifying, having to qualify that service really came into being, because it means that being in a financial institution, your conduct has to really be what one can best be described as impeccable. You do not have a second chance to form a first impression in a financial institution, because outside of the violence that it creates to the female employees in the organization, the customers also rely on the integrity of the employees in any financial institution, Republic Bank Limited being no exception. Having said that, when one looks at the fundamentals in terms of the framework, in terms of what employers have to work with, you have the OSH Act, and I'm happy to hear my friend Joy speak about Section 6 of the Act. But generally, the OSH Act, and I'm not here to knock any piece of legislation, is limited in the sense that it only refers to Section 6. Employers have a legal obligation to provide a very safe workplace. anything that wants to compromise that obligation has to be dealt with a certain amount of urgency. The courts have said on many occasions that is a zero tolerance when it comes to health and safety. So having said that, or having established that sexual harassment comes under the umbrella of misconduct, it means that no employer, and that's the guideline that we provide at the ECA, no employer should tolerate any kind of misconduct that wants to resemble anything under the umbrella of sexual harassment. So we have other pieces of legislation that we are guided by. The Equal Opportunities Act, the Industrial Relations Act, you also have the Sexual Offences Act, and of course we have the ILO conventions, and last but not least, or I should say first, our Constitution, Section 4 of the Constitution, really, which supersedes all other pieces of legislation. And if I do some as an attorney, it's because I'm starting to become one by force. All right. So at the ECA, what we do as well is that we treat sexual harassment as part of the framework in terms of managing risk. It is an act of misconduct. We look at what we have in terms of the legalities, the judgments coming out of the court. That Republic Bank would have been the first one. If my memory serves me correctly, we have about 4 or 5 now on the agenda. And interestingly enough, excuse me, interestingly enough, there's another one that I want to refer to, NGC, and I think it was All Trinidad was a union at the time. My comrade Julian referred to a young person or a temporary employee. In that particular judgment, that employee suffered the fate of having to lose her job because her contract of employment really was used to kind of substitute or to hide behind the veneer of what was taking place at the company at the time, which is unfortunate. The court did award some kind of damages to that employee, so that is commendable on the part of the industrial court. So it means that as employers, we take a cue from the things that come out of these judgments so that we urge other employers not to repeat these mistakes as we go forward, all right? Because it is all about providing a safe workplace. The other thing that can happen in terms of what we do in terms of telling employers about sexual harassment is that an employee has the option to do one out of several things, which is to file a discrimination claim to the Equal Opportunity Commission. And I don't know that any employer would want to welcome something like that. It really speaks to the tone set in that organization and what exactly is it, in place to deal with when an employee comes forward to make such a claim. Sometimes an employee is not readily going to advance that kind of information. And I don't know that anybody wants to come forward to their supervisor or their manager, especially if that is the person who is engaging in that kind of conduct, to readily disclose, well, here's what, I am the victim of sexual harassment. I don't know, because most times there's a fallout to that kind of thing. So employees would shy away. So sometimes in terms of the statistics, we don't have it. But at the ECA, we are painfully aware that things take place in and out of what we are currently seeing in the media. And I'm going to be speaking about that. I'm not in black today. All right. But we take a cue from all of these things because it means that this can happen in and out of a unionized environment, because there's a myth that permeates throughout the society that you only have situations such as these when you have a unionized environment. It can happen outside of a unionized environment, and all the more reason why the ECA has to get involved, because we have to guide employers at the end of the day to let them know that there's a particular way that you meet and treat with employees and how you deal with the issues that they bring forward. Because failure to do so can result in not just the loss of productivity, you can have disengaged employees. And as a child in the room, we read that new buzzword in terms of employment. We need to do in establishing that what happens is a stress. It must be comfortable environment. Claudia, I know you spoke about the correlation between having a safe workplace and engaged workers and the level of productivity. At the ECA, we support that because we believe that we need to be proactive. Because, as they say in Trinidad and Tobago, hindsight is 20/20 vision. And hindsight at the industrial court could be very costly. All right? you can find yourself as an employer having to pay some hefty fines. You also have to pay attention to the reputational risks that can be had if you come forward with a sexual harassment judgment against you. All right? So it doesn't help with your customers, it doesn't help with the other employees who are also in the organization, because you must have things in place to deal with the impact on them as well, because they too are impacted. Because remember, it's a negative culture, it's a hostile environment that is evolving, and one has to demonstrate that all the employees, on a point of fairness and equity, are treated equally. One of the other things that I wanted to speak about was sometimes in this kind of arrangement with sexual harassment claims, we as employers have to be cognizant of the fact that you have the same sex complaints, you generally tend to have the opposite sex complaints, but you have to pay attention to those matters that come before you. Having said that, it means that your training has to deal with a lot of sensitivity. It is not about how we as employers feel in terms of a moral stance. Diversity is now the new buzzword at the workplace, and these issues come under the umbrella of diversity. You have to treat with these matters with the sensitivity and the objectivity that is required. Because it's easy to adopt the stance. No, I'm not in support of that. Nobody asked for your opinion. As professionals in the workplace, we have to guide employers as to how to treat with the employees, because the Industrial Relations Act, we are guided by section 10.3. Because when you look at any judgment coming out of the industrial court, you must have reference to section 10.3, and it's all about fairness and equity. So every single training program that you will see coming out of the ECA, you will, I guarantee you, there will be a slide that references section 10.3 of the Act, because there is no getting away from that. The other thing that we guide employers to do is not just to have a policy. Policy is a noun, you must have a verb to go with that. So there must be a procedure. So we have guidelines with regard to the policy and the procedure. You must also have not just one forum in terms of one route to make that complaint. There must be several options open to the employee. Ideally, what we recommend at the ECA is to also have an anonymous complaint line so that the employee is protected at the end of the day. The other part of it in terms of the balancing act, because we never lose sight of that scale that is always before us at 7 St. Vincent Street. In the event that the complaint, let's say for some reason or the other, finds itself grounded in mischief, you have to also deal with the perpetrator who came forward creating that mischief. So it's important in having a policy to deal with all sides of the divide, because we know, yes, we have talented employees, and sometimes, as we said, they are grounded in mischief. People do things, and at the end of the day, yes, one is guided by he who alleges must prove. With sexual harassment, it's not very easy to prove. However, you must have some way of gathering that evidence that points you in a particular direction. And last but not least, in terms of reporting and containing that information by way of the investigative process, the training is a part of it. You also have to get statements from other witnesses if it is that we are in the world of technology, although I'm not the beneficiary today. If you have pictures and so on that can substantiate your claims when you come forward, it will help conversations with people who would have witnessed some of the things, the unsavory comments that would have been directed at you. We encourage employees to come forward in that regard. And we have guidelines as well for the victim. You know, during the process of the investigation, we try to tell the person to stay calm, you know, document the things that you consider to be offensive, and always the employee assistance program in the interim, because this is a very traumatic period for any employee. And as Joy said earlier on, it doesn't impact the employee alone. Remember, the employee is not a standalone person. He or she belongs to a family unit. So that whole family now is impacted. So it means that the employer has to put things in place so that that employee can be as comfortable as possible under the circumstances until such time that that investigation is closed. We do not recommend taking disciplinary action before that investigation is completed. However, there would be times when you would have to remove the alleged perpetrator by way of a suspension until such time that the investigation is closed. So we always guide employers in terms of the disciplinary process as well as the disciplinary action. So the action comes at the end of the process. So we try to get employees to list the actual allegations, and we are also guided by the court, the industrial court guidelines. So I wouldn't want to spend too much time on Republic Bank because I'm not here to speak about Republic Bank this morning. But one of the things that the court said in that matter is that the employee engaged in a pattern of offensive behavior against other employees, which fell within the corridors of dismissible conduct. One other judgment that I would want to refer to would be a ready-mix judgment, which was quite interesting because Claudia spoke about when exactly is work. There was a work function outside of work hours, and the young lady said no to the young man's advances. As it turned out, complaints were made to the HR manager at the time, and the matter went forward as a trade dispute. What the court said at the time was that they were very concerned about the conduct of the employee outside of the workplace, and it had to form the basis of disciplinary action because, remember, he's going back into the environment to work with the employee. So it means that while the actual environment at work was not hostile, it would have become hostile because of that interaction outside of the workplace. So I found that judgment to be quite interestful. So I wanted to share that with you all. And last but not least, there was another judgment that came out of the court. TCM lease, rental company, and banking insurance. In this particular instance, the employee did come forward with a sexual harassment claim. Unfortunately, in terms of the process, the employer didn't do what was required of him or her, and as such had to pay the employee damages. But it's not to say that the matter that came forward, there was no merit in the claim from the employee. So it means that this too serves as a guide for us as employers. You must follow the process. Because you see, in the heat of the matter, what may very well happen is that you concentrate only on the victim and you may not pay attention to the harasser. So it's important that we have that balance, because the scale for the ECA is always important because we have a critical role to play at guiding employers with regard to best practice, all right, at the end of the day. Let me take the opportunity on behalf of the ECA to thank the Equal Opportunities Commission for having us on this auspicious occasion. And I also want to take the opportunity for the ladies in the audience to wish you all happy International Women's Day on Thursday the 8th. And we would want to continue in this arrangement with you all as partners in this very important exercise as it relates to sexual harassment. Thank you, ladies and gentlemen.
Thank you, Ms. Estrada. So you've heard the ECA, you've heard NATUC, you've heard the ILO, and now we move to the specific launch. And to do this, we are bringing no other person but the chairman of the Equal Opportunity Commission, Ms. Lynette Seabrand-Sweet. I think all of us in this room, all of us are familiar with her and her work in the field of law and the rights of women and children. And so I don't need to add any more to that. She made sure she told me that too. So I introduce, bring to you, Ms. Lynette Seabrand.
Thank you very much, Deputy Chairman of the Equal Opportunity Commission, Dr. Beckles. At this time in the proceedings, I think that I can say all protocols observed, except, of course, to recognize the distinguished panel, in particular our minister, who has always been a champion in whatever endeavor she engages in, and in government, she continues to be that champion, and we want to deepen and foster that relationship among us as stakeholders and actors in the sexual harassment debate with the Minister of Labour. We need that champion in the House. Of course, Madam Konya, who brings the international flavor to the discussion, and who in her wide-ranging discourse has given us much food for thought in terms of where the conversation must go, of the work that the ILO is doing. We have, of course, the trade union collective that has given us that impassioned contribution, and as well we have the Mrs. Strutter from the Employers Consultative Association, whose most valuable contribution, I think, this morning for me is to remind us of the precedents that have been set in the industrial court. And my legal team is going to be, our legal team at the Equal Opportunity Commission is going to ask you specifically for some of those cases that we were not aware of. So that I want also to recognize some of the key players in this sexual harassment discussion or disco dialogue that has been going on in Trinidad and Tobago for at least a year. And I want to acknowledge Mr. Parsanlal, who was one of the persons who assisted us in refining the guidelines, and mention Professor Antoine, who also performed a similar function. We have some very important human resource professionals, Mr. Parsanlal being one of them. I recognize Ms. Cavell Joseph, and I did see Madam in the back there, also from AFET. Who else is there? Of course, we have Terry Ince, who has also been an important discussant in this sexual harassment debate from the Network of NGOs for the Advancement of Women and from the CEDAW committee that has been carrying the burden. We have members of the press. I see Mr. Anizet, who has joined us. So in addition to which, we have, of course, the media, who have been also fostering and providing the medium for carrying the messages. And let me as well recognize the Equal Opportunity Commission team that was responsible for actually doing the bulk work in producing the guideline, Mrs. Furlong and Ms. Peters. So with that, probably have taken up half of my time there. I wanted to focus today not so much on a repetition of what is in the guidelines or to gild the contributions that have already come from this distinguished panel, but to focus, hopefully with a laser focus on the question of what exactly do we need to do in Trinidad and Tobago in terms of legislation. Where do we need to take this dialogue to bring us to the point of legislation? What exact legislation do we need? And in addressing that, I just want to draw to our attention that there are several territories in the Caribbean that have already legislated for sexual harassment using different models. We have, for example, the St. Lucia and the Bahamas models, which models really take the of sexual harassment criminal, where what you have is a person who is guilty of an act of sexual harassment is charged in the courts, and there is a court process, and the person may be found guilty, may be fined, or they may be imprisoned. This is not a model which I suggest would be useful in Trinidad and Tobago, as it does not address the issue of prevention, nor does it address the question of providing any remedy or redress to the victim. So we do not want to suggest in Trinidad and Tobago that we go the model which creates sexual harassment solely as a criminal offense. We have Guyana and Belize, which have improved models. In particular, in Guyana, sexual harassment is recognized under the Guyanese equivalent of the Equal Opportunity Commission. But their Equal Opportunity Commission in Guyana deals only with gender. And it is not an Equal Opportunity Commission which has a scope as broad as the Equal Opportunity Commission of Trinidad and Tobago, which I'll very quickly get to in due course. Belize also has a very interesting model, but in Belize, again, the dispute is carried into the normal courts, and where there is a bit of, not I would say an anomaly, but a unique situation where the High Court in Belize is given, as it were, an inquisitorial function in conducting an investigation, which is something that is not quite knows that model in Trinidad and Tobago, where the court itself undertakes a responsibility for conducting an investigation. Because how we are accustomed to operating is in the adversarial mode, where you have two parties who, as it were, duke it out in front of the court, and then the court makes its decision. So that itself is a unique, which perhaps is not suitable for Trinidad and Tobago. In Barbados, there is a very interesting model, and the model, I think, which is the most progressive in terms of the Caribbean countries. That is a model which recognizes the role of the legislation in Barbados to protect workers. I believe it's called the Employees' Rights Act. And that is what I am particularly interested in hearing about from our minister, in the sense of the basic conditions of legislation and exactly going to fit into the whole infrastructure legislation and infrastructure of procedures and tribunals that is already available in Trinidad and Tobago. And so I'm very interested to understand how the Basic Conditions of Work Act is going to work in terms of providing a remedy for sexual harassment. So we are going to be getting into that discussion with you, madam, and with you, Madam Kunya, in terms of what the ILO has to bring to that question of what model we put in place. Now, what I wanted to do, well, of course, one will have seen from the guidelines that there is some sort of framework already in existence in Trinidad and Tobago in terms of the IRA, in terms of the occupational health and safety legislation, and in terms of even the civil courts. And what we are very much messaging is that the Equal Opportunity Commission is one of the most suitable avenues for bringing a complaint of sexual harassment, apart from the landscape which already exists, largely the industrial court. Now, if you look at I did prepare a PowerPoint which really was to compare the CARICOM model bill, which is a very important instrument that was prepared under the Justice project of under the auspices of the Canadian government. They have you can't get it open, so we have a complete anyway. So let me just then speak to a very brief comparison with the CARICOM model bill and the Equal Opportunity Act to see exactly what really is the best model for Trinidad and Tobago. Well, that CARICOM bill prohibits sexual harassment specifically because it is a CARICOM bill dealing with sexual harassment, or a model bill. It prohibits sexual harassment in certain areas, very similar to the areas that are covered in the Equal Opportunity Act. So, for example, the CARICOM Act prohibits sexual harassment in the provision of goods and services, in the landlord and tenant situation, in the buying and selling of land, in educational institutions at every level, not only university, but vocational adult education at every level of educational institution, and also in professional bodies, trade unions, and associations. Well, of course, the CARICOM bill covers sexual harassment in the area of employment. And it is quite sophisticated in that it not only deals with the workplace, but it also deals with employment agencies, and it deals with commission agents and partnerships. So it tries to tie up every situation in which you may have something akin to an employer-employee relationship. Now, the CARICOM bill, when it deals with what is the responsibility of employers, it creates a duty on the part of the employer as opposed to the other areas that I've spoken of. Specifically, it creates a duty on the part of the employer to issue and publicize a policy. So this is what the model legislation does. It creates a duty on the part of the employer to create a sexual harassment policy for the workplace and also to publicize that policy. And that is where I am suggesting we need to go in Trinidad and Tobago with whatever legislative instrument we devise after we achieve consensus. The one thing that this legislation needs to do, if it doesn't do anything else, is to create a duty so that each employer must now have a duty under the law to create and publicize a policy within the workplace. And what is good about this model CARICOM bill is that it creates this duty on the part of the employer, not on the part of the institution, to create a policy, not only on the employer, but on institutions such as hospitals, orphanages, homes, those kinds of institutions where there is a risk of sexual harassment occurring, and also on all educational institutions. So, for example, the University of the West Indies of Trinidad and Tobago, the TechVoc sector, all of training institutions and educational institutions now are mandated that they must create and publicize a policy. And that is something that what I am saying is that whatever legislative regime we come up with in Trinidad and Tobago, that is a key element of the responsibilities and duties that would be created by this legislation. Now, so the CARICOM bill also has specifics as to what the policy, sexual harassment policy must include. I don't think it's necessary for me to go into that sort of nitty-gritty here. But interestingly, it makes the employer liable, of course, where the employment occurred in the course of employment, and it could, of course, be actually in the workplace or as highlighted by Ms. Estrada, in a situation which is akin to the workplace. And so you see the need for perhaps a broader definition of the workplace. And it creates a liability for the employer, where first of all, the employer was informed. So the first thing is that the employer must be informed, and the employer must not have taken reasonable steps to prevent continuation. So that is where the responsibility, the liability of the employer is created. He must know about it, and he must not have taken reasonable steps to prevent its continuation in a particular instance. And if it is that the employer is found not to have taken reasonable steps, then in addition to whatever it is that the employee did, the employer itself becomes liable to pay the victim, reinstate the victim, whatever is the particular appropriate remedy for the occasion. So this is another important legislative provision that must be in there, in whatever legislative architecture we come up with, the liability of the employer. Now, of course, the CARICOM bill prohibits victimization and also sanctions malicious complaints. Victimization is one of the principal bugbears of sexual harassment. The problem is that you make a complaint and then you frequently find yourself on the receiving end of victimization, and you yourself end up being the one perhaps who is forced out of the workplace, who is managed out of the workplace, because you're seen as a troublemaker and someone who is not as valuable perhaps to the organization as the person who may be higher up who may be a key man in the organization, and the organization prefers to keep that person. So you are victimized and you are forced out. And we see that enacted. We see that enacted on the national stage from time to time, and it is very much the experience of persons who complain about sexual harassment in a workplace which is not sensitized and attuned to the evil of sexual harassment at the highest level, and then the person then jeopardizes their future by the act of complaining about sexual harassment. So whenever a code or whenever a legislative architecture is being designed, the question of guarding against victimization and the question of in the modern era, what we have a lot of is the question now of what I deem now social media justice. So that if the organization does not itself have an internal conscience, the risk in the modern era of reputational damage really performs a salutary effect on the willingness or unwillingness of the employer to deal with this problem. As soon as they see that their sales are being jeopardized, their reputational risk is being jeopardized, and so on, they want to deal with it. Well, that is where you're dealing with commercial houses, with agencies that are buying, that are providing goods or services or products. It's very easy to mobilize them, but it's less easy to mobilize other kinds of institutions where sexual harassment is taking place. For example, we see in the United States of America how difficult it is to move members of Congress who have been accused. It takes a long time, weeks, months before you get any action, whereas in a trade house, it's instantaneous because of how instantaneous the reputation to your, the damage to your reputation can take place. Now, the CARICOM bill also provides, and all of the provide that is complaints procedure in the organization. If that fails, there is a mediation process in the external agency. And then if that fails, then there is recourse to a tribunal or a court type structure. So this is what the CARICOM bill envisages, that the workplace must have a code. If that code fails, the employee must have recourse to a conciliation process in an agency outside of the workplace. And then even if that conciliation process fails, then there is recourse to a court type hierarchy, which has the power to impose sanctions, impose fines, impose injunctions, impose reinstatement coercively if that is what is needed. Now, so let me just very, very quickly describe how the Equal Opportunity Act already fits into this model architecture which the CARICOM legislation has provided, which, just to reiterate, creates a duty on the part of the employer, also covers other areas of endeavor, apart just from the employer, creates a duty on the employer to promulgate a code, creates a liability on the part of the employer if they do not act reasonably, and then provides a remedy outside of the workplace, where first you have conciliation, and then if the conciliation fails, you have recourse to a court. Well, let's see how the Equal Opportunity Act measures up to that standard that has been proposed, that scheme that has been proposed in the model CARICOM bill. Well, first of all, the Equal Opportunity Act prohibits discrimination in relation to employment, which is what we are principally concerned about, in the provision of goods and services, in the field of education, and in the provision of accommodation. So right there you see the lineup between the Equal Opportunity Act and the CARICOM model bill. Secondly, the Equal Opportunity Act prohibits discrimination following sex. We have a problem with our legislation, which we have to wrestle with and to get a longest while. In our legislation, sex does not include sexual orientation. Orientation is specifically excluded. That is an amendment that Equal Opportunity Commission has been lobbying for years, and certainly since the current regime is in place since 2014, we have put up a recommendation to our minister, which is the Ministry of the Attorney General, to get that changed, to no avail as yet. We need champions for that amendment, which is it's so easy. It's so easy. I mean, a government will get so many kudos in doing that. Think of the acclaim on the international stage. Trinidad and Tobago's parliament has amended the Equal Opportunity Act to include sexual orientation. It's just a win-win, but it hasn't happened as yet. We're hoping that it will happen. So in Trinidad and Tobago, our act prohibits discrimination on the basis of sex, race, ethnicity, religion, marital status, and disability. Very similar to the CARICOM model bill. And of course, we have heard from the discourse, there's no question that sexual harassment is a subcategory of gender discrimination at every level in all of the conventions, the CEDAW Convention, the ILO conventions. Sexual discrimination is a very clearly defined and recognized subset of gender discrimination. And our act also, as with the CARICOM model bill, prohibits victimization and also creates an offensive behavior, which I need not go into for our purposes. Suffice to say that if it is that you use language in public which is offensive to a group, then that is an offense. So if you get up in the square and you start talking about all persons of a different orientation or all persons of a different race, and you incite hatred on the basis of belonging to that group, you are committing an offense under the Equal Opportunity Act for which you can be charged. So therefore, now the EOC remedy, how the EOC remedy works is this. You have a complaint that you have been discriminated against in these 4 areas, including employment, on the basis of sex, which is to say sexual harassment. So this is what has happened to you. Employment, discrimination, sex, harassment. Come to the Equal Opportunity Commission. You make a either online or in writing. The Equal Opportunity Commission has a machinery in-house which starts off with an investigation. So the Equal Opportunity Commission does the investigation and then provides the conciliation service free of charge. Now, you wonder what teeth does the Equal Opportunity Commission have to compel the employer to come to the table. Now, one can never compel a party to arrive at a solution in conciliation, but one can certainly compel someone to participate in the conciliation, and that is where the Equal Opportunity Commission has teeth. Because if our respondent, who is usually, well, it would be an employer, where the complaint is in the area of employment, if the employer fails to comply or fails to provide the information, as they frequently do, they can be charged in the magistrate's court for the offense of not providing the information required within a reasonable time. And if they are found guilty, the penalty is $1,000 for every day that the information remains outstanding. And that tends to focus the minds of employers who want to disregard the Opportunity Commission and say, who are they? Who are you? You can do anything. So then they quickly learn the Equal Opportunity Commission teeth. So they then come to the table and they bring the information that is needed and they participate. But as I have said, you cannot force somebody to arrive at a decision in a conciliation. So if the conciliation fails, the Equal Opportunity legislation has created a tribunal, the Equal Opportunity Tribunal, which has the of a court. So you can then take your complaint to the Equal Opportunity Tribunal, which is up and running in existence and has given about 10 very important judgments in its short life, in which you would have seen in the newspaper and so on. Time? And I'm almost finished. And so what I'm saying is that the Equal Opportunity infrastructure and architecture, which is already in existence, is most appropriately poised to form the principal avenue of complaints of sexual harassment. But as I said, we need a legislative instrument which is going to create duty on the part of the employer to formulate a policy in the workplace, to publicize the policy, and then create the liability on the part of the employer if it does not act appropriately. And then we want the conciliatory mechanism, and we want then the recourse to the court if the conciliatory mechanism fails. So the other thing which the legislative instrument can provide is assistance with the question of definitions. So what we are saying is that we do need legislation in Tobago which would use the architecture of the Equal Opportunity Commission and the infrastructure of the Equal Opportunity Commission, which is already there and which already in its state points has received complaints. So I am very interested in conclusion to work with the work that the Ministry of Labour has been doing in preparing the legislation that you speak about, to see how everything dovetails and exactly what instrument we come up with, what is the model that we decide on at the end of the day. So that really is how I see the work forward. So with those many words, I can't say few words. With those words, I would want to formally launch the guidelines of Equal Opportunity Commission to acknowledge the work of all of the persons who have participated in the dialogue that has been going on at an intense level among all of the stakeholders for at least a year in Trinidad and Tobago, and to acknowledge the important work that the key stakeholders that we have brought here today have to. These are not the only stakeholders, but these are key stakeholders. We have been operating with other stakeholders from time to time. This particular group of stakeholders is a key group of stakeholders, and we are very pleased that everybody took the time to participate in this. I feel some energy as to the possibility of moving forward with this. So with that, I would open up the discussion to the moderator to see whether anybody has time for a little discussion. But I must excuse the minister, who has been here for a long time and who has indicated she must leave now. Oh, what do you do?